Welcome back. You're listening to Houston Real Estate Radio. I'm your host, Shannon Register, and every week we bring you news and information you can use on your next real estate transaction. And today is all about buying large property, normally, usually not your neighborhood tracts, but large properties that come with oil and gas leases, and whether you even want those oil and gas leases. We've talked about a lot of different things today. Last segment, we were talking with Judon Fambro from the Real Estate Research Center over at Texas A&M University. And we gave you a real broad overview of mineral rights in Texas. And so this segment, I want to get a little bit more focused and talk about the contractual aspects of it. And after we do, you're really going to realize that you need an attorney to help you with that. So I've brought an attorney, Daniel Shank. He is from the Coates Rose law firm. He is a director at Coates Rose, and he's been a trial lawyer representing oil and gas companies. So he's got a lot of experience with this. So we're going to pick his brain for a few minutes. And then, if you need help with an oil and gas lease, you may want to give him a call because he's got some great information for you. As always, when you're listening to the show, you can stream it on iHeartRadio, and you can find us online and watch all the videos of today's show if you miss any of it at HoustonRealEstateRadio.com. So we're going to go ahead and get started. Daniel Shank's come into the studio. He's from the Houston office of Coates Rose. We appreciate you coming in.
Well, thanks for having me. So
let's get started really diving into contracts, because last segment we got a great overview, and so I want to talk more about the contracts. And I think that when people buy ranches, it doesn't even have to be a ranch. It could just be 5 to 8, 10 acres. Sometimes you're using a contract where if you do have mineral rights, you have to know whether they're conveying or not. So let's talk a little bit about the contract. Is our contract that we use in real estate, that's the promulgated forms, are they set up to automatically transfer any oil and gas rights over to the buyer, or do you need to write that in if there is anything being transferred?
Well, the way the forms are set up is you're conveying fee title, then the minerals are included if it's 100% fee title. Mm-hmm. And then there's a TREC form that's an addendum where what you would do, that's the Texas Real Estate Commission form, where you would reserve out, or the seller would reserve all or a portion of the minerals out. Mm-hmm. Also, you can certainly have a lawyer draft one, and I would recommend not blindly using forms. Mm-hmm. Or you should have a lawyer look at them and make sure they're done properly. But at the end of the day, if it says fee title, and if it, depending upon the warranty that's provided in connection with the deed, mm-hmm. whether or not they're warranting 100% of title, or if they're a reservation, normally they would put a reservation exception of the minerals if they're not being conveyed in the deed. But the contract would call for them to, if it says fee title, it's conveying fee title. If they're going to reserve it out, there's an addendum that they would add to reserve out the minerals.
So in a real estate transaction, you need to make sure that the contract's right, and then you also need to make sure that the deed is prepared correctly.
Well, yes, but the way that works is ordinarily, you'll have a title company. Title company will hire, and if you have a financing entity, either the title company or your lender will hire a law firm to look at the title commitment, look at the earnest money contract, and prepare the appropriate instruments to close. Mm-hmm. Be that as it may, you're better off making sure you have your own lawyer look them over too, because those people don't necessarily work for you.
Right. Yeah. Title company's kind of intermediary.
Well, no, exactly. That's what they are. That's what they are. They're just an agent to close the deal.
Yeah.
And then if there's a lender involved, when the lender hires that mm-hmm. person, that lawyer, they're asking that lawyer to do the work to protect the bank, not necessarily protect you, even though you get the benefit of paying for their legal fees as part of your loan commitment.
If you do hold back your mineral rights per the contract and it doesn't get written into the deed, can you go back and fight that later?
Well, what I would perceive as a problem is that the contract merges into the deed, mm-hmm. and so it might be barred. At the same time, though, if it's a scrivener's error or mutual mistake, you can seek to reform the deed, or you could bring a claim for specific performance. But I would be surprised that somebody would draft a deed that didn't comply with their earnest money contract.
The contract. So sometimes, this gets a little complicated. Somebody may be purchasing 200 acres, and 100 acres of that, you may have a fourth of the mineral rights, and then a 25 acre, you may have a third of the mineral right. It gets a little complicated, right, on exactly what you're getting. So can you on that amendment that you were talking about where you can convey minerals, can you just say that all of the mineral rights that the seller owns are going to be conveyed to the buyer, or do you have to stipulate out exactly what it is that's being conveyed?
Well, as long as you have an adequate legal description of the property involved, you can then convey whatever the owner has.
Okay. And then do you find that normally the title company does research it and find out exactly what's being conveyed, or they just...
No, well, title insurance is different than... title insurance. Title insurers are not required by state law to insure the mineral estate. And normally they're accepted out. So they won't do anything with reference to the minerals. You got to do that work on your own. And the way you do that is you get an abstract of title, or you have a landman go run title for you and figure out, what are we talking about here?
What is able to be conveyed?
Yes.
Mm-hmm. All right. And that gets complicated and costly.
Well, I mean... But at the same time, I've often seen that an ounce of prevention is worth a pound of cure.
That's true. That's true. Very true. All right. If let's see, I know there's just so much to talk about. It's so complicated, the whole thing. But when you see litigation with these oil and gas companies and consumers who own, or not really the consumers, but the landowners, what's the what major things are you seeing? What are some of the repetitive topics that you see coming up that are the main issues that you've had to deal with? Because you have years of experience in this. What are the main issues that you see?
Well, very often, you'll see title disputes, who owns what.
Okay.
You'll see surface damage claims where they say that there wasn't a reasonable use, or there was an unreasonable and unnecessary use of the surface estate. Really, a lot of what you see is latent environmental claims dealing with historical operations that were done back in the 30s, 40s, and 50s, when you could have an unlined earthen pit or stuff like that where there might be hydrocarbons that remained in the ground that were, say, an unlined pit where they're using for disposal purposes or the like when they're drilling the well. And then, all over East Texas, they just covered them up.
Yeah. Oh, wow.
And so you see a lot of environmental issues.
Okay. And that causes problems with building structures later?
Well, not building structures. It's just that let's say that you determine that you want to make some use of your property, and you go out there and you get a soil study done or have an environmental assessment done, and they determine that historically there was a well in this location, and you start poking around, and you'll find out that there were 3 unlined earthen pits, 50 yards to the south of the well pad.
So if the owner of a property is going to sell their property and they own some mineral rights and they've agreed to transfer those mineral rights to the new buyer and they have a lease on those mineral rights, does the lease automatically convey as well?
Yeah, it's subject to the lease. And so they don't have to, you could assign the lease, but since they are conveying the mineral rights, that in and of itself is an assignment of the lessor's position.
Okay. So it's going to transfer to them. Okay. And when the property is for sale, you could still sign a lease, get the bonus, and then transfer it, right?
Well, yeah.
As long as you still own it.
Yes, but
Because I would imagine there are some people who do that right before they sell.
Well, yeah. When things were hot with the shale plays, you might see that happen. But the bonus for the initial term. Sure, okay, that's cash in your pocket right now. But then ultimately when it's developed, if you've sold the minerals, then that estate, that lease goes to the benefit of the current owner. And so they'll get the royalty interest moving forward. They
just wouldn't get the bonus.
Yes, but I would think that parties who are sophisticated enough to enter into a couple $100,000, a multi-million-dollar transaction would probably pick up on that.
All right, so let's talk about water rights. There is a lot of water being used right now for fracking purposes. Is there any way for the landowner, if they're doing a lease on their property, is there any way for them to protect that water?
Well water is not part of the mineral estate. Okay, produced water, which comes from an entirely different horizon. These wells are being drilled 8,000 to 10,000 feet deep. That's not potable water. That's not anything you would want to, give to your cow or drink.
Right. But it is affecting some of the water in the area.
Well, now, also you have to remember is that the groundwater is usable. In other words, they can capture groundwater, but you're not going to find that happening that often. The water's going to come from someplace else. The more interesting question is what do they do with the water after it comes out.
Okay.
And
all right.
there's currently a big issue right now about using an old well for disposal purposes and injecting water into the ground, and whether or not that is a proper use as well.
Do you think they should be able to do that?
The Supreme Court's going to rule on it. It's been before them once and was reversed on certain grounds, and the Texas Supreme Court's going to decide whether or not that's included in the rule of capture. I don't think, from personal viewpoint, I don't think injecting water is part of the rule of capture.
All right. Well, we appreciate your information. Great talking with you, because you just have a world of knowledge. And I guess the biggest piece of advice to give people is to get their own attorney.
Absolutely.
All right. We appreciate it. From Coates Rose Law Firm in Houston, we appreciate you coming on and all the great information that you brought to us today. And if you have a real estate question, you can call us at 281-882-8088. And if you missed any of today's show, you can catch us online at Houston Real Estate Radio. Have a great weekend. We'll be back next Sunday between 11 and noon.